Welcome back. You're watching Court TV. I'm Ted Rollins. Before the break, you heard the Durst defense introduce a new theory of the crime. Well, that somewhat cordial argument quickly devolved, forcing the judge to step in to referee.
The problem is Susan Berman made the phone call on February 1st. The problem is this information was not reported. It first appeared in the New York Post on, I believe by memory, February 8th or February 9th.
Yeah, but he knew about it before the Post.
Let's back up. We don't have, right now, Your Honor, we have no foundation that is correct. What we have is, well, again, as the defense said, Boston Commons, I think is the show. There was a Boston Legal, they used to have, they would call it Plan B. They're in the middle of court. They filed a motion, completely different purpose.
I guess there's a little...
And now, let me finish. Mr. Ray just made the point. Hey, Judge, listen. If we think of something, some crazy theory in the middle of trial, whether it's relevant, whether it's what we said before, hey, we should be able to throw it up there and see what sticks. Here's where we're at, Your Honor, with the point that I'm making. They are now saying, well, wait a minute. It's not relevant because Bob Durst would have known that the elevator operators had seen Kathy before Susan Berman made the call. But here's the problem. By Mr. Durst's own statements regarding his timeline, he doesn't even realize that Susan Berman, the Kathy, is missing until February 4th. He thinks that she is just allegedly doing rotations at the hospital. So let's understand what they're saying.
Wait a second. That means you can cross-examine him on that, and he'll be proved wrong.
Well, Your Honor, there's a difference between...
Well, that means that she's alive.
Trust me. Cross-examination is going to get your popcorn and your candy and a lounge chair because it's going to be a while.
Sure.
But here's the problem. Whether I can impeach Mr. Durst during cross-examination is a different issue than whether, in fact, we should be interjecting complete hearsay disguised for some non-hearsay purpose when they keep throwing out, Your Honor, different non-hearsay purposes. Now, as the court said, in their opening statement, they gave themselves away. They are not trying to use this for a non-hearsay purpose, Your Honor. They are trying to use this to try and influence this jury that, in fact, Kathy Durst was seen. That's an observation the court made in looking at their opening statement. So, again, Your Honor, for all the reasons that we've said, and the most important thing that needs to be done right now, Your Honor, is simply the defense should not be allowed to discuss this issue in opening. That gives the court the entire time until Mr. Durst testifies to assess whether or not the court believes it's relevant, whether or not the court believes it's 352, whether or not the theory and the information and evidence that they have produced is consistent with it, then the court can make a ruling.
Your Honor, can I just...
Time out. Wait a minute. Hold on. Mr. Bailey, hold on, please. Your Honor. Well, let me see.
The hearing's louder.
He's got his hands on. Oh.
Look, this isn't some late arrived theory. We've known from the beginning that Eddie Lopez saw Kathy Durst on February the 1st. They say they offered to stipulate to that. No, they offered to stipulate to anything that was otherwise admissible. It was clearly a hearsay statement. So we couldn't stipulate that. So, but
wait a minute. That's a lie. But that's not a lie. It's a lie. Could you stop Mr. Floyd?
Down.
Your Honor,
Everybody go to your corner. Come on, be seated. No, be seated. Sit down. Sit down. No speaking. Sit down. Right. No, you may not continue. We are going to be silent now. Mr. DeGuerin, you may speak first.
thank you. The offer to stipulate was to otherwise admissible testimony. Of course, we couldn't stipulate because it wasn't otherwise admissible. Mr. Durst kept abreast of what the police investigation was. He was very relieved find Eddie Lopez to be innocent, and that Roberto Vittori had seen Kathy Durst on February 1st. He reported her missing several days later when she didn't show up. And that started the investigation. The investigation by Strzok developed those two witnesses, among others, but those two primary witnesses. Mr. Berman says that Eddie Lopez was impeached. Here's about that. Eddie Lopez went and underwent hypnosis. He underwent that other thing that starts with a P, I'm not supposed to mention here. And he drew or helped draw a picture of the man that he took up to Kathy's apartment 30 minutes after she went up to the apartment. All of that was very heavily investigated by the police, and that encouraged Mr. Durst to know that they were doing a good job, and hopefully something would come of it. And he was not even considered a suspect at that time. It was later in the investigation that they considered him a suspect.
Whew, man, it's kind of exhausting to watch that. Let's bring back Matthew Barhoma. The timeout seemed to work there. The judge had them both sit in silence for a few minutes, and then one by one they articulated their argument. Besides the dramatics here, what's your take on the fact that at the 11th hour, the defense wants to change their theory and bring in this semi-hearsay evidence, and they want to talk about it in openings, the state saying, no, they can't. What do you think the judge should have done here?
You know, it goes to show you just how much these parties are going to contend each other. First and foremost, rules of evidence generally are a little bit more lax during opening and closing statements, certainly not to the extent where you can confuse the jury, especially when there's already COVID-19 related items that already make it difficult to hear and process in sincerity. But ultimately, the fact that they're fighting this much this early on is certainly an issue. Now, with that being said, the defense is allowed to establish the theory that it wants. Okay, if they're going to confuse the jury, sure, the judge definitely needs to get in and put a stop to that, or at least a limit to that. But if they're going to be advancing an honest, merit-based arguments, they're allowed to make the arguments that they need to, and by no means do they have to disclose that to the people. The prosecution does carry the burden to prove beyond a reasonable doubt, and if the defense is establishing a theory that is casting doubt, they're allowed to do that no matter where in trial they want to be.
Prosecutor Lewin obviously is very invested emotionally in this. He has been fighting for years to get to this point, to get to trial. Because of his emotional nature and the fact that he is so invested, does he have to watch out as trial moves forward that he doesn't have too many outbursts in front of the jury? Because we saw it during the first openings 14 months ago. He got frustrated. Then it was the 14-month shutdown. Does he have to watch himself?
Absolutely. I mean, the parties currently are speaking to each other, including with the court, in a very candid fashion. I mean, they're getting right to the nit and gritty of this case, which is good, especially when we're not in the presence of a jury. Now, before the jury, they really got to clean this up and make sure that the jury doesn't see them fighting, rather sees them working through the issues. So certainly something that needs to be watched out for as the jury is in play. But could you also imagine the type of pressure that's on the prosecution? I mean, I'm sure the prosecution is very eager. And with that being said, emotions are going to ride high.